Friends, we are discussing about the Code of Criminal Procedure 1973. The Code of Criminal Procedure is a procedure law and the IPC is the substantial law. Indian Penal Code 1860 is the substantial law. The law of criminal procedure meant to be complementary to substantial criminal law. This sentence clearly says that the criminal procedure code is a complementary to IPC and other substantial criminal laws. It creates the necessary machinery for the detection of the crime. CRPC detention about how to detect a criminal case and arrest of the accused. How to arrest the accused according to CRPC. It is vested in CRPC and explained in CRPC. The collection of evidence. CRPC again says that how to collect evidence in a criminal case and recording and framing of charge. How to frame a charge and how to record the depositions or the statement of the witness that are dealt in the Criminal Procedure Code 1973. The determination of guilt or innocence of the person. After arresting the criminal and the collection of evidence and recording or framing of charge, the trial is conducted. After conducting the trial, the judicial officer will decide if the accused is guilty or accused is innocent and the imposition of suitable punishment on the guilt of the person. If the accused find guilty, the judicial officer in Indian courts imposes punishment for that guilty person. That all are discussed in Criminal Procedure Code. In addition to that, in addition to above referred things, what are the above referred things? Detention of the crime, arrest of the criminals, collection of evidence, recording and framing of charge, and determination of the guilt or innocence of the person. And after imposing the punishment, in addition to above referred things, the code also deals with the prevention of offence under section 106 to 124. How to prevent the offences to commit more offence. That also dealt under 106 to 124. And 129 to 139 also dealt how to prevent a criminal. And 144 to 153 also says to how to prevent a criminal. And maintenance of wives, children and parents. This is under CRPC 125 to 128. It is an important provision in the Criminal Procedure Code, irrespective of their religion, irrespective of their state, and irrespective of their caste. The Criminal Procedure Code 1973 imposes a maintenance provision for wife, children and aged parent. The husband exclusively omitted from the maintenance. And public nuisance under section 133 to 134. 133 to 134 says public nuisance under Criminal Procedure Code. It further attempt to strike a just balance between the need to give discretionary powers to the functionaries under the code to make investigative and adjudicatory processes strong and effective, the need of controlling the probable misuse and abuse of these powers. In this sentence, it says that the CRPC further attempt to strike a just balance between need to give discretionary powers and functionaries under the code. Under CRPC, it take a balance between need and discretionary powers. the judicial officer can exercise its discretion, but the CRPC imposes mandatory powers over the judicial officer. Under investigating to make investigative and adjudicatory process strong, effective, and need for controlling the probable misuse and abuse of powers. If the investigation agency misuse the power, or the investigation agency abuses the power, or the judicial officer misuse the power or abuse the power, the criminal procedure code controlling over the investigating agencies and the judicial officers. On the whole, the criminal procedure code is a uniform procedure law. At all, it is a uniform procedural law. On the whole, the Code of Criminal Procedure is a uniform law dealing in the matters of criminal proceedings for not applicable the state of Nagaland, whole except the state of Jammu and Kashmir. And considering the facts and circumstances of Indian judicial system, the Criminal Procedure Code is a uniform procedure code for the whole of India, except the state of Jammu and Kashmir. After the amendment of Article 370 of the Indian Constitution, the Criminal Procedure Code is also applicable to the Jammu and Kashmir. And further, the creation provision of the code have been made not applicable to the state of Nagaland and other tribal areas. In Nagaland and tribal areas, there is a separate criminal procedure code, so the Code of Criminal Procedure is not applicable there. And the areas of discretion left in the state of make such provision applicable by using separate notification. Not only that, the criminal procedure is applicable by the Nagaland government for separate notification. The code how far exhaustive, that deals with how the law is applicable in India. The code is exhaustive on the matter specifically dealt by it. The code how applicable, where applicable, which institution it is implementing agency is also dealing with in the Code of Criminal Procedure Code. However, it is not an exhaustive on the point is not specifically dealt there. However, it is considered that the Criminal Procedure Code is not an exhaustive law. Such a type of law will come time to time as per the amendment and enactment of the Parliament. The legislature is incapable of contemplating all the possible circumstances which may arise in future litigation and consequently providing procedure for them. If special circumstances arises, the legislature, that means Parliament and the state legislature, can make new law in Criminal Procedure Code and make amendment in respective field of Criminal Procedural Code. The legislature is incapable of contemplating all the possible circumstances which may arise in future the litigation and consequently providing procedure for them. And with regard to those matters, if a special circumstances arises, in considering those special circumstances, the court has inherent power to act according to the principle of justice, equity, and good conscience. The court must act justice, equity, and good conscience if a prevailing special circumstances arises in future. If any circumstances arises in future, the court must consider justice, Equity and good consent. Equity means it is a principle arising in the judicial system and legal system. Equity means balance of convenience and truth. Based on this principle, equity principle derives. And good conscience. In this regard, section 482 reads, nothing in the court shall be deemed to limit or affect the inherent powers of the High Court to make such orders. 482 clearly says the inherent powers of the High Court. If there is no provision in CRPC, such provisions, such situations can be dealt by the High Court under the special circumstances and inherent powers. Nothing in this code shall be deemed to limit or affect the inherent powers of the High Court to make such orders as may be necessary to give effect to any orders under this code, or to prevent abuse of the process of any court, or otherwise to secure the ends of justice. To establish the justice, to prevent the abuse of powers, the High Court can interfere in any matters if it is a new circumstance also. Table 1, the territorial division of criminal courts under section 7 and 8 of the CRPC. The state High Court, and it is again divided into metropolitan area. Every metropolitan area is separate session division, and the district is another division. Delhi is a metropolitan city, Bombay is a metropolitan city, Calcutta is a metropolitan city. In metropolitan area there is a metropolitan separate division. The state division is further divided into session divisions, that means district divisions. And session divisions is again divided into districts. District criminal jurisdiction is again divided into subdivisions. I hope that you must understand. You understood my lecture, and if any doubt you can comment in the comment box. Thank you.